Hello everyone. In our last few lessons, we've looked at a number of different legal cases, and we've seen that these cases can get extremely complicated. And if you're a litigant, either as a plaintiff or a defendant in one of these cases, it is extremely time-consuming and it is extremely expensive. And one thing you want to do as a small business is avoid dragging out these issues forever and avoid the incredible expense that you'll have to go to just in order to defend yourself or to press your case. So because court processes are so time-consuming, there are a few workarounds. Now, if you want to sue someone, or they want to sue you, we've already looked at all the different boxes that have got to be checked. You've got to have standing. You've got to sue in the right court. You've got to sue in the right place. You've got to notify the parties. You're paying an attorney. You're paying court fees. In some states, there are even special courts for special types of proceedings. So Massachusetts has a housing court for landlord-tenant disputes. Most states have family courts for family disputes. If there's an action by shareholders against a company, it's most likely going to take place in Chancery Court in Delaware. So again, this is a very time-consuming and a very expensive process. So a number of years ago, I purchased a house. And when we inspected the house, we noticed that the well pump was not working properly. And we wrote directly into the contract that the sale of the house was contingent upon the owner getting the well pump repaired. A few weeks passed. The person who owned the house got a contractor in. Contractor said they fixed it. Previous owner said she fixed it. We purchased the house. Well, it didn't take us long to find out that the issue had not been fixed at all. In fact, even the preliminary work that would have to have been done to inspect the problem wasn't done. And I went to an attorney. And I was told, even though the expense we had to repair this well pump was $2,500, I was told that we had a really good case, except that the legal fees involved in going through the regular court system would run us $20,000. Why would anyone want to spend $20,000 in order to win $2,500 back? Obviously, it doesn't make sense. So every state in the Union has what's called a small claims court. And in a small claims court, parties can litigate, as it sounds, small amounts of money. And it's a much more relaxed environment. Usually there are no attorneys involved, although you can have an attorney if you choose. The rules of evidence are relaxed. Hearsay evidence is admitted in. It's a much more informal structure. Sometimes it's a regular judge on the court who's actually hearing the case. Sometimes it's not. Sometimes it's an attorney who they borrow for the day or the week to actually sit and hear the case. In New York, Vermont, Connecticut, and Rhode Island, you can only take cases that are worth $5,000 or less. In Massachusetts, it's $7,000. In New Hampshire, it's $7,500. One of the drawbacks to going to small claims court is that there usually, in most cases, is not an ability to appeal if the decision goes against you. Well, why is that? Well, because as you all know, facts are determined at the trial court level. Appeals are based on errors in law, in the application of the law. Since the rules are relaxed on evidence and hearsay and things like that, that means there's always going to be an issue of the law at the trial court level. So in most states and in most cases, these are not permitted to be appealed. And even in states where you can appeal them, the courts look very, very harshly at these appeals. So, We ended up going to court. I actually ended up losing that case, and I do believe there was a mistake in the law as the judge applied it. Doesn't matter. I couldn't really appeal. So small claims court becomes an option, but it's not an option for everybody. Another approach that is taken, and this is especially the case when you've got a David and Goliath situation. You've got a party that doesn't have a lot of power, like an individual consumer of a good or service, or a small business, and they're going up against someone huge. They're going up against, Chase Bank, or they're going up against some major corporation. Obviously, the corporation has got the assets and the power. They have their own legal firm. They can keep things tied up forever with delays and motions, and they have a lot of money to spend doing a legal defense. So the little guy is kind of out of luck in trying to take an action against them. So this is where the concept of the class action case comes up. In a class action case, there is a lead plaintiff who is leading the charge, who says, I want to sue this company. And they hire an attorney or a law firm that is skilled specifically in class action cases. And in order to have a class action case, that means they have to certify a class. And what that means is the attorneys need to go to the court and argue that there is a whole class of people who have been injured in exactly the same way by this corporation. And the fact patterns are almost all the same. This might happen with a product liability issue. Someone sells a product and it goes on fire, or it breaks and harms someone, and it's happened over and over and over again. Well, it makes no sense for 1,000 different individuals to bring 1,000 different cases in 1,000 different venues and clog up the court system, and each of them individually going against the giant corporation. They don't have the money, they don't have the time, and you could end up with different decisions across 50 states too. So the class action approach says we will certify a class of injured people. Once they do that, anyone who is part of that injured class is part of the lawsuit. And if the lawsuit is successful, they actually win a percentage of whatever is awarded. You can opt out. Anyone who is in part of a class can opt out of that lawsuit and reserve the right to sue on their own. But once you opt into that lawsuit, you're in it. And if you lose, you have lost. You cannot bring suit on your own. Now what happens is the lead plaintiff, whoever started this case, and their attorneys that they've hired, they make the decisions. They make the decisions on should we say this, should we admit this to evidence, should we go for this amount of a settlement, should we settle out of court for this amount. If you have opted in and you're not the lead plaintiff, the upside is that you don't have to do anything. You basically don't have to show up in court. You don't have to give testimony. You don't have to do any of these things. And there is a possibility that you will actually get a monetary judgment in the end for doing nothing except opting in. The downside is that most class actions result in small amounts of awards for most people, and you have no control over the direction the case takes. That's in the hands of the lead plaintiff and their law firm. Now, to give you an example, if you've seen advertisements on TV for the last year about mesothelioma, that's a class action lawsuit. That's a law firm attempting to find people who are in the class of people who developed a specific disease as a result of their exposure to asbestos in a certain environment. That's why you see those ads. It's not like the attorney wants to take you on personally as a client. It's more the case that they're seeking to build the class of people who were injured with the same set of facts and circumstances. Most of the time, class action lawsuits are settled because instead of it being David versus Goliath, it's Goliath versus Goliath. It's a huge corporation against a powerful law firm, and it could go on for years and years. And it's usually in the interest of both parties to settle. Usually the settlement is for less than what the damages actually are. Once a settlement or a judgment has been reached, the attorneys usually receive 20 to 25% of the amount of that settlement. So if there's $1 million settlement or $1 million judgment, the attorneys will walk away with $250,000. The other $750,000 will be divided among all the members of the class equally. And I know sometimes you'll get a check or a notice in the mail, and I just got one recently for a class action suit against the milk industry for collusion. I got a check for $10. I'm sure the attorneys representing that class action lawsuit got a lot more than that. Most often these suits are not brought to get you a lot of money. They're most often brought to do a public punishing of the company and to try and get them to stop practice that has harmed a lot of people. So that's a class action lawsuit. Now we move into what is called alternative dispute resolution. And this is basically saying, let's stay out of the courts. Let's get this done without the high-powered attorneys and all the fees and all the time it takes. Most businesses engage in the first type of ADR, alternative dispute resolution, all the time. And it's simply called negotiation. Negotiation is when someone comes to your store and they say, you know what, I bought this last week and it's already broken and I want my money back. And you as a business owner says, well, I can get you a brand new one, you can try that again, I can give you a store credit, and you start talking back and forth about what's the best way to resolve this dispute. That's negotiation. 9 times out of 10, a business is better off dealing with a dispute exactly that way. Well, let me take care of this. All right, bring your car back in. We'll take a look at it again. I'm not going to charge you. Something like that. Because it's quick, it is inexpensive, it is not a big public brouhaha in the newspapers or in court documents, and it's also good business. So negotiation is always the go-to for dispute resolution that you have with an employee or a customer or a supplier or anyone else. That doesn't always work. Sometimes you don't come to an agreement on yourself. So then there are 2 more formal processes. The first is called mediation. Mediation is an entirely voluntary process. Both parties to mediation must voluntarily agree, yes, let's try this approach. And what they do is they get a neutral third party. And there are people who are members of national and state mediation associations. They're often attorneys. They're often retired judges. They're people who serve in this capacity. It is very informal. It takes 1 or 2 days. And basically everyone comes together and sits around a table. And the mediator says, all right, what happened here? And each side tells their story. No rules of evidence, nothing really legal about it. And then the mediator will meet with each of the individuals separately and talk to them separately and try and get an idea of what would be, where can they find common ground. As I said, within 1 to 2 days, the mediator brings them together, and it could be the same day, and says, I've listened to the story, here are the issues as I see them. I think a good compromise or a good settlement would be, and he lays it out. Now, rarely does anyone get everything they're looking for, but quite frankly, if you go to court and you're paying court fees and attorney fees, you're also not getting everything you're looking for, and you're not getting it swiftly. The mediator offers you a good compromise. It is completely within both parties' right to accept or reject what the mediator comes up with. If you don't like what the mediator has come up with, you don't have to abide by the mediation, and you can proceed to litigation, to a court process. But mediators enable you to, turn the heat down a little bit, come up with a compromise that gets it done and puts it behind you. And it's not legally binding, it's not public, it is an agreement that this is how you'll handle it. Now, if one person agrees to the mediation and then doesn't follow through, then the other party is going to have to go to court. But they'll be able to say, we went to mediation, we tried to resolve this, and the other person agreed. And that will be allowed as evidence in that trial court. But mediation is a good way, it's a good first step to try and get things resolved. The final alternative dispute resolution technique, which is growing in leaps and bounds across the country, is something called arbitration. And because there's a federal statute, the Federal Arbitration Act, there's also state arbitration acts that refine things a little more. And some of them make it so that it's not binding, so they'll call it binding arbitration or non-binding arbitration. For our purposes, going to arbitration means you are going to a binding decision. And here's what I mean by that. In binding arbitration, it's usually done before a panel of 3 people. And once again, there are people who are official arbitrators, retired judges, attorneys. You choose one. The person you're going against in this action, they choose one. And then those 2 arbitrators have to pick a third arbitrator, and they have to agree on it. So now you've got a panel of 3 people. In arbitration, it's a little more formal than mediation. The rules are a little, not as tight as a courtroom, but a little tighter than mediation. It doesn't take as long as a court process, but it takes a little longer than mediation, sometimes up to a week. And it's a similar process to mediation. They hear all of the arguments. They will sometimes call in witnesses or have what's called discovery, which means interviewing other people who might be witnesses or somehow other parties to this. They will come up with a decision. The difference with arbitration over mediation, this decision is binding. Once they have come up with a decision, that is the decision. Both parties are bound by it legally. The decision of the arbitrators is often filed in a court without all the proceedings that went before. And the reason for that is, and one of the benefits of arbitration, is that it's still confidential. See, when you go to court, all of this is out in the open. Court stenographers taking down information. You've read legal cases where the facts were read right in the case. In arbitration, all the information is confidential, which for many people, especially if there's trade secrets involved in how your business runs, this can be a really important reason to prefer arbitration or mediation over the regular court system. It is usually not appealable. Once again, if you decide to go to arbitration, it must be voluntary. So the two parties have agreed we are going to arbitration. We will be bound by the results of that arbitration, and there is no appeal. It is, again, quick, not as expensive as the courts, and it keeps the courts from being clogged up, because these cases are being decided before any papers are ever filed with any court anywhere. Now, because of the binding and relatively inexpensive and quick-moving nature of arbitration, many contracts have mandatory arbitration clauses in them. Now, as I said, both parties have to voluntarily agree to arbitration. I suggest you read the fine print in the contract you have with your credit card company, because 23 out of 29 of the largest credit card companies in the United States, in your credit agreement, have an arbitration clause saying that if you have a case against them for something they've done, you do agree by accepting the credit to go to arbitration rather than taking them to court. Now, to bring two concepts we've discussed already together, back in 2013, Lori Scott in California discovered that Chase Bank had enrolled her in an overdraft protection program that she did not opt into and she did not want. And what happened was she overdrew her checking account by 26 cents. The bank paid the overdraft, and then they charged her $50. Well, she found out she wasn't alone in this, and in fact, Chase Bank had racked up $5 million in overdraft fees by enrolling people in this program who had never asked to be in this program in the first place. So, she got together with a lot of other people who were similarly charged. There was a whole bunch of them. David and Goliath situation. So what does that sound like? Class action suit. There was a class of people harmed by the same set of facts. Class action suit was brought, and they lost. And the reason they lost was a procedural issue, because the court looked at the contracts that each individual had with Chase Bank, and it said any disputes will be settled by arbitration. By accepting that credit, you voluntarily agreed to enter into arbitration if there was a dispute. Therefore, the entire class action suit was thrown out. You may not like that result, but that's why you have to read your contracts. Financial institutions make a lot of use of arbitration clauses. There are arbitration clauses in a lot of employment contracts. Read your employment contract if you have one. I know at GCC, where I work, we have a union that represents us against management when necessary. And if there is a dispute, someone didn't receive a course they think they should have received because they had seniority, or they had a course they were preparing to teach and it was canceled at the last minute because there wasn't enough enrollment, and the college says we're not going to compensate the instructor who's been working for the last few weeks putting a course together. If this cannot be resolved, it goes to arbitration, because the contract the union has with the state says that disputes will be settled by arbitration. And the employment contract I have says I am represented by the union and this is how we do things. So they're in employment contracts. Nursing homes frequently use arbitration clauses for any litigation or disputes that their residents or their residents' caregivers might have over what's going on in the nursing home. And they're being used more and more. one of the really touchy areas of the law right now. It's a real hot button issue, and it may be resolved in the next few years, or it may continue to go on, are sexual harassment disputes in the workplace. When Congress passed the Federal Arbitration Act, they did so under the Interstate Commerce Clause, which gives them the power to do so. And the idea was to cover business disputes. Employment disputes could also generally come under that broad topic. In many large businesses have arbitration clauses that sexual harassment claims have to be also sent to arbitration. And when you sign your employment contract, you've now voluntarily agreed to that. There is some discussion that this is not related to the conduct of business. It's not related to employer-employee compensation issues, that this is outside the scope of what the act was meant to cover. So far, most courts have said, you sign a contract that's got an arbitration clause, that's where you bring your case. And some sexual harassment cases have been brought under the arbitration clause of their contracts and won big money. So it's not necessarily something that's anti-employee, because it's actually a much quicker, much more confidential, and much easier way to go. On the other hand, the Fifth Circuit Court of Appeals has ruled that the Federal Arbitration Act is not meant to cover sexual harassment, and they're allowing independent litigation to go forward. And that now means there is a split in the country, depending on what states you are, as to whether someone who's got a case of alleged sexual harassment can use the courts or need to go through binding arbitration. So that's an overview of alternative ways of handling cases. In most cases, if you've got a small business, it's going to be an alternative dispute resolution mechanism that you will be involved in. Most of the time, simple negotiation. Let's put this behind us, let's create goodwill, let's avoid the expense and time. Sometimes it'll be mediation, and that's a really good way to also resolve things quickly and at low expense. You may not get everything you want, that's life. And sometimes it'll be arbitration. But these arbitration clauses are now being used more and more in contracts. If you're having a home built, and I don't mean you're having some repairs done by your local contractor, who usually has a very simple contract, but a large home built from scratch, a developer, there's almost always an arbitration clause in that contract. So it's important to read contracts. It's important to read the fine print, because many times when you think you've got a case against someone and you want to go to court, you can't. You have an avenue to resolve it, but it's going to be different than the court system. There are many attorneys, many judges, many legal minds who think arbitration is actually is the positive way to go because of the advantages it has. There are others who are less sure about that and want to allow an avenue for litigation in some of these cases. It is an area of the law that is changing and is in flux, and hopefully you'll never have to encounter it, but there's a good chance you will. So, Tom Simmons signing off. I'll see you next week.